Good afternoon. My name is Bonnie Stewart, and I'm the Executive Director of the Connecticut Society of Certified Public Accountants. I'm here today to comment on two bills, Senate Bill 1090 and House Bill 7373, both of which are measures that the Department of Revenue Services requested from you. I'm going to start off with HB 7373. This is a measure that in part is an attempt to try to address some of the unforeseen consequences of Public Act 18-49, the measure that concerned pass-through entity tax and a few other things. We support this measure as drafted, but there are three additional modifications we would like to see. The first has to do with bonus depreciation. I've spoken with some of you over the summer about it, as has our contract lobbyist. This is a section of the statutes that was adopted retroactively. Actually, it went back to a closed tax year, 2017, and that has created quite a bit of frustration and increased cost, and not to mention time, because it's changing what you can deduct. It's not changing that you can deduct this item, but how you can deduct it is a better way to say it. What we would appreciate is if you would make that optional for 2017, and then it obviously would go into impact for everyone in 2018. The state does not lose any money by doing that, and the thousands of tax returns that would have to be amended now won't have to be if they correct it in this 2018 tax year. So that would be our first request, and I've submitted language on that. The second has to do with penalty and interest waiver. Because of the retroactive application of the law, people are going to be subject to penalties and interest for things that they had no way of paying because the law wasn't in effect. So we're asking that you adopt a penalty and interest waiver for anything that is the result, or a late payment that is solely the result of the retroactive application of the law. And that language I've supplied you as well. The last thing for 7373 has to do with indirect and direct owners. So when you have a multi-tiered public or pass-through entity, you can have one pass-through entity that owns another pass-through entity, and they're not eligible right now to take advantage of one of the offerings through the pass-through entity modifications that were made. We're asking that you clarify in the statute that it doesn't matter whether you're an indirect or direct owner, that you're still eligible for that credit. Again, I've supplied that language and appreciate it if you would adopt that. Moving on to Senate Bill 1090, I'm only testifying regarding Section 1 of that bill. A couple of years ago, this committee adopted a change in how payments would be made to the Department of Revenue Services. So you said penalties would have to be paid first, taxes second, and interest third. The Section 1 of this bill would change that back to penalties first, interest second, and tax third. So for someone who's trying to dig themselves out of a hole and working with the state to pay, you're throwing dirt back on it and making it that much more difficult for them to get out. Given the fact that you already have the penalty imposed on them and our interest, which is more or less a penalty, a second penalty, because it's 1% simple interest per month, 12% a year, quite high. To switch this back, we feel would be just another penalty on someone who's trying to, like I said, get themselves out of a hole. Thank you for your time, and I'm happy to answer any questions.
Thank you for your testimony. Ms. Stewart, are there any questions? Representative Davis.
Thank you. Thank you, Ms. Stewart, for your testimony. I had a question for you, and perhaps you could explain it. In Bill 7373, I know that the Commissioner had mentioned in his testimony that this is a result of talking to tax preparers after implementing the pass-through entity tax. And one of those sections, lines 39, or should I say starts on line 38 to 42, talks about excluding any item or anything item treated as an itemized deduction for federal income tax purposes. And I was wondering if you had any insight as to why that would be inserted into the bill. Was that something that came from your industry, or?
That's not enough information for me to answer, but if you if I can just touch base with you quickly after I testify, I'll get the numbers, I'll go back, check my notes, and shoot you an email.
Okay.
Thank you.
Thank you.
Thank you. Any additional questions? Yep, Representative Sulo.
So I'm the new guy on the block, so you're going to have to educate me just a little bit. this section 1 of 1090, does this also apply to, for example, if I'm a restaurant collecting like a sales tax that I'm supposed to remit to the state of Connecticut that I collect in a fiduciary capacity? Does this also apply to repayment of that? Let's say I fail to remit those sums.
Yes, so anything that is owed to the state right now in terms of back taxes, late taxes.
Okay.
It's set forth in statute that right now you'll pay the penalty owed for late or insufficient, then the tax will be paid, and then the interest last. This
So-
measure, regardless of which tax it is, whether it's the state sales tax, the income tax, corporate, whatever, it is switching that so that it's penalty, interest, then tax.
So do you think, and now this is just an opinion question, do you think that there's a reason to draw a distinction between maybe an income tax that somebody fails to pay and a tax that somebody collects in a fiduciary capacity? Because I know, having worked in several different industries in my life, that a lot of ways that business owners sometimes skirt the rules, and they obviously shouldn't, is that they collect these monies that they're supposed to collect in a fiduciary capacity, and they fail to remit them. Now, they're collecting them in that fiduciary capacity, that which they're supposed to turn over to the state of Connecticut. In my mind, I'm thinking, well, if they're collecting it and supposed to be turning it over right away, then maybe it's not such a bad thing to have them. They're obviously using that money for their own gain. Maybe it's not a bad reason to be taxing them in this fashion, as opposed to what you're recommending.
My big concern has to do with the income tax portion of it, or
Okay.
anything where unexpected things, so if a law changes, types of things. So I'm not going to justify someone not turning over their sales tax. I don't know how they would do that, to be quite honest. I don't know if the computer system at DRS would permit that. But our goal here is for individuals or businesses, which usually small businesses pay through the personal income tax, is if they found out that they didn't have enough withheld, or a bunch of different reasons, somebody's trying to work with the state, to then have them have the interest paid before the tax, just it does a disservice to the taxpayer. I'm not talking about the type of people that are fraudulently not turning it over. That's not what we're trying to protect here.
So in my experience, I've seen, and maybe it has changed, but I've seen instances where you can file the return but not actually make the payment, as far as turning over sales tax. And so I'm in agreement with what you're recommending as far as the income tax goes, but if that's still the case, I would be interested to see if maybe there's an opportunity for a carve-out, where if it's something like a fiduciary tax, maybe the more, I hate to say
Right.
draconian, but the version of this where it tends to penalize the taxpayer more would be in effect.
I understand what you're saying, and I'd be happy to ask my members if you'd give me until after April 15th, which is only next week. I think they'd be more happy to give me a response.
I appreciate it, and I thank you for the time, and thank
You're
you, Mr.
welcome.
Chairman.
Thank you. Any additional questions? Seeing none, thank you very much.
Thank you.